Hi, everybody. My name is Emily Taylor. I'm an attorney in Arizona, and I appreciate you joining us today to learn a little bit about Social Security. I have Tye Smith, also an Arizona attorney here. And Tye, tell me a little bit about yourself. We're going to talk about Social Security today, but how did we get here?
Well, I grew up in Salt Lake City, Utah, and I attended the University of Utah. My goal when I went to Utah was to become a sports reporter. I'm really into sports, and I'm kind of a junkie with football and things like that. So I spent a lot of time in that field. And by my senior year, I realized that really I wanted to become an attorney. I had been a competitive debater in high school and had really always been good at arguing. And so I decided that that was the route for me. I got into ASU Law School and I attended there from 2007 to 2010. And I've been in Phoenix ever since. And I'm a Social Security disability attorney, but I still love sports, but now this is my focus.
Well, I won't pick on you too much. I went to U of A for law school, but I did go to ASU for undergrad, so
Okay,
we'll be
okay,
okay, I think.
okay.
And do we root for the Cardinals in your house?
Well, I am a fan of the Denver Broncos because I
Oh,
actually lived there when I was very little, but the Cardinals are my adopted team, and I always cheer for them unless they're playing the Broncos.
okay, perfect. So you mentioned you're a Social Security attorney, and I meet with a lot of clients day in and day out, and I talk about concepts of Social Security. But what does it mean to be a Social Security attorney?
So I am exclusively practicing in the area of Social Security disability, and I have since 2011. What it means is that we are representing people who are applying for disability benefits through the Social Security Administration. There are many kinds of disability programs that are private or that are funded by other agencies. My work is specifically designed for people who are applying for disability through Social Security.
Okay, and I understand you're a partner at a firm. Can you tell us a little bit about your firm?
I can. We have three attorneys here: Jeremy Peckus, Sterling King, and me. Jeremy Peckus is my partner. The name of the firm is Peckus Smith. This firm has been around in various iterations for more than 30 years. I've been here for 2 years. I came here because of the tremendous amount of respect that I had for who is now my partner, Jeremy Peckus. We had become friends over the years, meeting up at hearing offices and through Social Security events. And then our one associate is the only person I've ever met who went to law school to become a Social Security disability attorney. So I think we have a really good group of people here and we have a lot of respect for each other. And it's a really great work environment and a really good place for people to come if they need representation for a Social Security disability claim.
Perfect. I'd love to hear more about what exactly a Social Security event is, but we'll leave that for another time. At the at the most basic level, can you tell me a little bit about Social Security disability? When you say those words, what's that mean?
Okay, so Social Security, the SSA, Social Security Administration, provides a number of programs for people to get disability benefits. And in order to qualify, generally speaking, you have to have a medically determinable impairment or combination of impairments that are expected to last for 12 months or longer and that would prevent a person from sustaining any full-time competitive work. So there's a lot of caveats in there, a lot of different ideas. The major issue is that you're not able to do a full-time job because of your conditions and that you have a condition that's chronic, that's going to last more than 12 months, and that will prevent you from being able to do full-time work for at least 12 months or longer.
And now I kind of think about Medicaid and Social Security kind of as an alphabet soup. We've got all these acronyms, and I'd have to ask folks to forgive us if we throw some of them around. But SSI and SSDI are the two that kind of come up at the top of the list for me when it comes to Social Security. Can you walk us through those two programs and what that means to you?
So those are the two major disability programs that are run by Social Security, and there are acronyms all over the place for each one. SSDI stands for Social Security Disability Insurance. Some people call it SSD, which is Social Security Disability. And Social Security itself calls it DIB, disability insurance benefits. So they're always finding ways to confuse us with these acronyms, but those conglomerations are all the same thing. And what it is, it's an application for disability benefits based on your work history. When you're working and you're paying taxes, a part of your taxes go to FICA, and the FICA taxes, a portion of them are given to Social Security. Those are funding your Social Security retirement as well as your Social Security disability. So if you make a claim for disability benefits based upon your work history, the benefits will be paid from a fund that you had paid into. It is based on your lifetime earnings, the amount that you would get. It varies for every person, but it is a claim for benefits based upon the work that you have done. You do have to have at least 5 years of work credits over the last 10 years in order to be eligible. Eligibility requirements do get somewhat complicated. Bottom line is you have to have worked for a significant period of time in order to gain eligibility, and then you can apply for SSDI, making a claim for disability based upon the money that you have made and paid to Social Security. The other kind of disability benefit that you're going to hear about a lot is SSI, and that stands for Supplemental Security Income. Supplemental Security Income was originally designed, as Social Security was, as a means to help older people who don't have the work credits to be able to get Social Security retirement. And it was eventually extended to people who are under the full retirement age as a means for them to be able to get disability benefits if they don't have the work history to be able to get the other kind. Now, eligibility for SSI is based on financial eligibility. So instead of relying on your work history, they're going to look at your financial situation. It is a needs-based program, and people with significant income or resources are not going to be eligible. The rules are technical and somewhat complicated, but the bottom line is that if you've been able to get approved for Arizona State Medicaid, that we call Access, and if you have food stamps, it's a pretty good sign that you're probably eligible for SSI, as many of the criteria are very similar. Now, with SSI benefits, Social Security is going to make specific determinations based on finances about how much money you're going to get. So a lot of people who get SSI don't even get the full amount that you could get under the law for various different reasons. The important point is that it is a needs-based program as opposed to being based on your work history.
So just so I'm getting this straight, SSI and SSDI share 3 letters, but don't even stand for the same ones, right?
That's exactly right. And I mean,
Okay.
the SS is the same, Social Security, and it is very confusing because they're so close together, but they're very different programs from an eligibility perspective. However, importantly, they do share the same criteria for what it takes to prove that you should get onto disability. In other words, the medical determinations are the same, and the rules for proving that you are disabled are the same for these programs.
Perfect. And I work with a lot of families and individuals where we're trying to protect SSI benefits. And so many of my clients may have heard me say a few things about this. Now, the other piece that I hear from time to time is this DAC, or Disabled Adult Childhood Disability. There seems, again, like a lot of acronyms or a lot of terminology. Can you walk me through how that might fit in or kind of cornerstone with these other programs?
Absolutely. So, DAC claims are what we call them, DAC, that stands for Disabled Adult Child. Once again, I don't know why attorneys and people in the public use different terms than Social Security. Social Security usually refers to it as a childhood disability benefit application. A disabled adult child claim means that you are between the age of 18 and 22. So you have to be over 18, you have to be under 22. You have to prove that you're disabled in that age range, and then you can make a claim for benefits based upon a parent's earnings record. So you're not necessarily forced to show the SSI eligibility, but you can do it based on a parent's earnings record. The only caveat is that you have to have a parent or legal guardian who is retired, disabled, or deceased. And when we talk about retired or disabled, they very specifically mean that they are on Social Security retirement or Social Security disability. For example, a person who has a parent who was on VA disability would not necessarily be eligible for that program. It is very important for Social Security to find that you are disabled within that time period in order for you to be able to get those better earnings based upon a parent's earnings. And so that's a program that's going to be very similar to SSDI because it's based on a person's work history and contributions to Social Security. The only difference being that it is not the work history of the claimant, it is the work history of a parent or a legal guardian that would be used to eventually pay out those benefits.
So if I'm following along, there's also the potential that at different stages of my life, I could be considered disabled, but on different programs, and that could change. Is that true?
That is absolutely true. And one of the things I wanted to bring up is the importance of applying for SSI benefits between the age of 18 to 22 if you are a person who has a disability, even if you are not financially eligible or would only get a very small amount from SSI. And the reason is that if Social Security finds you disabled on that application, if you don't have a parent who is retired, deceased, or disabled at that point in time, you may down the road. And so if you have a parent who retires or passes away or ends up being on disability, but that doesn't happen until 10 or 15 years after your 22nd birthday, it's much easier to retroactively apply for those benefits where you would have had to prove disability between those ages because you already did. And so Social Security can look and say, well, we already found that you were disabled during that time period. And so now we can find you disabled for the purpose of your application for disabled adult child benefits.
Holy cow, this is complicated stuff.
It is. I know.
So I'm meeting with folks a lot during the transition period of kind of that 18 to 22 period. And my understanding, correct me if I'm wrong, is that when an individual is applying for SSI benefits and they're under the age of 18, Social Security will look at the financial resources of their household or family. Is that correct?
Yeah, so that's really important because I didn't mention child SSI benefits earlier on. A person as early as birth can be found disabled for child SSI purposes. The requirements are different because you're not going to be looking at whether you can work or not, but they are going to look for very significant impairments that affect a child's ability to go to school or even just to function around their family. The key being that the only kind of benefits that a child can get through Social Security is SSI. And that's when they're going to look at the parents' income. And if the parents have significant income or resources, then the child will not be eligible for SSI. However, a lot of kids who are disabled aren't eligible for child SSI benefits, and then they turn 18. And once you turn 18, the evaluation shifts for financial eligibility purposes. And instead of looking at your parents' income, they're going to look at your income. Now, they will still consider some factors, including whether your parents are paying your rent or helping you with other important parts of your life, but they're not going to take the parents' income and evaluate that for SSI eligibility. They're only going to look at it from the perspective of the amount of help that they give you once you turn 18. So there are a lot of people who become eligible for SSI benefits right when they turn 18, just because Social Security is going to change the way they evaluate that person's financial eligibility.
So we have this big 18th birthday coming up. Do we start our SSI application before that, or should we actually wait until the birthday's happened?
I don't know how early Social Security will actually let you do it, but probably about a month before the 18th birthday would be a good time to start getting your ducks in a row and potentially even file the application. The reason that can be important is that SSI benefits are only payable as of the month after you apply. So if you turn 18 and you wait 6 months to apply, then those benefits are only going to be payable the month after you turn after you applied, not when you turned 18. So you may have missed out on a number of months of benefits if you wait to file the application.
Okay, so you say filing an application. I've heard many different ways we can kind of go about doing this, and some of it changed as a result of COVID, perhaps. But can you walk me through how I start an application for
Yeah.
SSI?
So filing an application is relatively straightforward. You need to do it with Social Security, and there are a number of ways that can be done. You can visit a local field office. They don't always take the application right when you show up. Sometimes they'll schedule a time for you to come back. But as you mentioned with COVID, those things changed a little bit, and they opened it up so that they were more willing to take applications over the phone. Importantly, though, that if you call them, you're going to wait on hold for a long time. That got a lot worse during COVID. It's getting better. They knew it was a problem and they are working on it. But there are significant hold times. And when they answer, they're probably not going to take the application right then and there. Instead, they would schedule a time for you to have your SSI application done. It's something that would take probably, in most cases, well over a half an hour up to an hour, because there's a lot of information that they have to obtain. But it can be set up beforehand by going to your local field office or by making a phone call. Applications can also be filed online at ssa.gov. And so that's another way that that can be done. Doesn't work as great with SSI applications because there are so many questions about financial eligibility that they're usually going to end up calling you and having a conversation with you anyway. But it is at least a way to get the process started and to trigger that series of communication with Social Security.
Okay. Let's say I am a parent and I'm intending on starting the SSI application, and I've decided to make an appointment, and I am thinking, do I bring my child with me, my now adult child? Do I bring my wagon of boxes full of paperwork? What's kind of some good tips for how that process actually goes, what they should consider?
Okay, so having the child with you is very important in most situations if the child can be with you. Social Security does need to know that the child is on board with doing this process. And once a child turns 18, they are going to have some autonomy to be able to make those decisions. And many children have cognitive impairments or learning disabilities or other very severe mental health conditions that may make it harder for them to make those choices, and in some cases may not even be legally responsible for making those choices. But if you have the child with you, you're not going to have any concerns about whether guardianship that you may have of your child will be enough to cover their right to file for Social Security disability. And a lot of guardianship agreements don't. And there's a lot of different kinds of ways that you can have control of your child's income. Obviously, Emily would know a lot more about those than I would. But I think it's a really good idea to have the child with you, because the child, in many cases, I would even say in most cases, will be needed to sign some documents to agree to move the process forward, to sign some releases for Social Security. And also, they start making observations about the claimant, the person applying for benefits, right off the bat. And the people who take the application will record their comments about how much need the person had and how difficult it was for them to communicate with or without their parents. And I don't really like that they do that. I don't think that they're doctors or that they're in a position to be making those comments, but it doesn't change the fact that they do. And because they're making these observations and they're recording them, that information will eventually be passed on to the people who are making the decisions, and it will form a part of their overall decision. So yes, take your child to the appointment if you can, and if you can't, you need to be able to explain why the child can't be there. But if you can, you should definitely do it.
Okay. Now you mentioned SSI and SSDI consider disability the same. And I imagine, walking through all of this, there's medical and non-medical information they're considering, just like you mentioned, how they appear in that meeting. Can you share with us a little bit about what that starts to look like and what kind of things they're looking at or looking for?
Okay, let's start with the application. What do I actually need for the application? And I know that you had mentioned, what am I supposed to do with these boxes of records, and how are they going to take that into account? You don't need all of that for the application. For the application itself, you need a few basic things that you want to gather before the application is filed. You need to know the names of the medical conditions that are preventing the child from being able to work. You need to know who they're seeing, what doctors they've been to, and what hospitals they visited. Social Security is most interested in where they have been up to 1 year before they file the application. And that kind of brings up another question of, what about all these records from 5 years ago and 10 years ago? Social Security doesn't consider those as much unless the condition is really severe to the point where there is no treatment available, and they did evaluations a while back that would probably still be conclusive. Most of the time, Social Security is interested in the current doctors and the current things that they've been doing for treatment. So you'll need a list of the conditions, you'll need a list of their doctors and hospitals they've been to, you'll need a list of medications that they're on right now, and you'll need any information about their work history within the last 15 years. In many cases, there won't be any, but in some cases, there has been some work, even at the age of 18. And Social Security will want to know what jobs that person has done. So it's not a super complicated amount of stuff that you need to file the application. It's mostly information, and then Social Security can request records from various sources. I would say that if it's a child who's 18 who recently graduated from high school or is still attending high school, that information about their current school will be expected. And it would be good to have the most recent IEP for Social Security that you can submit to them right off the bat. Again, that isn't needed for the application, but it is something that you would want them to have as quickly as possible so that they can start to evaluate what impairments the school found needed assistance, and that can start to inform their decisions as they decide on the case.
Okay. And so talk to me a little bit about kind of young adults and older adults, but this idea of working, trying to work, right? We're all, not all, but a lot of us are hoping for independence. We want to encourage that. We want to see progress. As a parent, we're thrilled when we see some of that, but it seems to kind of contradict what Social Security might be looking for. And I know your answer is we just need to be honest and truthful, but can you share some of the things they are going to be looking at or evaluating in going through some of those records?
Okay, so let's start with the question about working. I think that you had mentioned that, and then we will come back to all of the things that they're looking at and that they're evaluating, because you might be surprised by some of those things. From a work perspective, remember that we go back to the rule that we're trying to show that you cannot sustain full-time competitive work. And so that begs the question, well, what if I can sustain part-time competitive work or full-time non-competitive work where I'm in a highly accommodated work environment working with other disabled people? And there are certainly a number of situations where that becomes a highly relevant question. There's a few concepts I want to address with respect to work before we go into those, just to give you a general idea of how Social Security looks at it. Social Security has a concept called substantial gainful activity, another fun acronym that they call SGA. You can find it online at any time by using the Google terms SGA chart SSA. That's what I use. It always brings up the exact chart, and it will tell you what constitutes SGA for a given year. SGA for 2023 is $1,470 per month. That's a gross number. That's before taxes. If you are earning more than $1,470 per month and you are doing that consistently, Social Security will say that you are making too much money. You are able to engage in substantial gainful activity, and they are usually going to issue a technical denial when that happens, which means that they didn't consider the medical and what the medical says. They just found that you were working too much to be able to get disability benefits. And there is then the caveat of, what if I'm making all this money, but My job is an accommodated work environment. I work at a grocery store as a bagger, and my employer provides me with a lot of additional assistance, and they let me be late, and they help me adjust my schedule, and they do all of these things. Well, there are situations where a person who is working at above SGA levels can still qualify for disability, but it is exceedingly difficult because you have to get statements from the employer. Social Security will need information because they have to make a finding that even though you are making SGA income, that it does not equate to SGA because it is not competitive work. And so that is something that can be worked around, but it's hard to work around it. And usually, if you're earning at over SGA levels, Social Security is going to want to deny the case. Now, there are some other topics that come up. People apply for disability, and a few months later, they decide that they would like to try to work. And it could be for a variety of reasons, including economic need or just wanting to have something to do during the day and to be productive and feel good about what they're doing in life. Social Security needs to know and be informed of any work attempt. That is something that you say you will inform them about when you file the application. And if you start working, you got to let them know. And then they will monitor the work attempt, because if you don't make it very long, then it's not going to result in a technical denial, and it might end up being an unsuccessful work attempt. We can see unsuccessful work attempts that last anywhere from a few hours up to a few weeks. And at the maximum, it could be for 6 months. Now, if you go beyond 3 months, it's harder to prove that this was an unsuccessful work attempt, but there are ways to do it. The bottom line, though, is just because you try to work doesn't mean that you're automatically going to be denied your disability claim. They need to watch it and pay attention to it and see how you do. And if you are able to be successful for an extended period of time, then it could lead to a denial, but it doesn't automatically do it. The key questions are: how long did you make it? What kind of adjustments needed to be made during the work attempt? Why did it come to an end? And ultimately, how much money did you make in that work attempt? And all of those factors will be considered. And so it's really important to know that just because you start trying to work doesn't mean your disability claim comes to an end. It has to go for an extended period of time before that concern really starts to show up. And the other final question, issue then that I wanted to talk about is, what about part-time work? Social Security's definition of disability has to do with full-time competitive work. So what if I work and I don't make $1,470 a month? What if I make $1,000 a month, or something along those lines? And the important thing to know is that Social Security has regulatory authority to consider anything that you do in your life, including part-time work, as a part of their overall consideration of whether or not you are disabled. So you might start working and you're earning at standards that are well below SGA. You might be making $1,000 a month. And Social Security can't technically deny your case because you're not earning at the substantial gainful activity levels, but they can evaluate that work activity and use it as a part of their overall formulation to decide if they think that you actually could do full-time work, and that your part-time work may give them a reason to think that maybe you could do full-time work. So it's important to know that any work that you do during an application for disability benefits can have a negative effect on the case. That doesn't mean that you shouldn't do it, and that doesn't mean that it will automatically lead to a denial, but it is important to know that any work activity whatsoever can be considered in an application, and you're not just fine as long as you're earning it under SGA levels, and a lot of people really do struggle with that.
Does that apply to like volunteering and like church programs and things I'm not actually getting paid for? Are they going to find out about that stuff?
Yes, it absolutely does, unfortunately. And that kind of brings me into the next part of your question, which is, what does Social Security consider? What are they going to look at? What do they need to see to find out if you're disabled? And first of all, they need to know the diagnosis. They need to know the conditions that you've got, and they need medical evidence that supports the existence of those conditions. However, the existence of the conditions is rarely enough to win. Social Security wants to know specifically in your case, how has the treatment been working? And what have you been doing to try to get better or to improve your symptoms? And how seriously affected are you in your life by those symptoms? So while Social Security will start with a focus on the medical records, that is not the end of the evaluation. They may find that there's a lot of good records that are supporting really significant restrictions, possibly even supporting that you are disabled. But they also look at your activities of daily living. And a lot of people are very surprised to hear about this. And I've seen a lot of cases in my life that are very good cases on paper that end up getting denied because of a person's daily activities. And that can include things like part-time work and volunteering and going to school, caretaking for a very young child, or for parents who are having significant issues, or even a spouse. And a lot of those things can ultimately end up creating a scenario where Social Security doesn't think that you're living a disabled lifestyle. In other words, that you've had adaptive functioning, or that your symptoms aren't as severe as you're telling them. And they're going to draw that conclusion based on the activities that you tell them about. They're also going to base it on the activities that show up in your medical records. And people are often very surprised to hear that their trip to Europe last summer was included in the medical records. They're like, how did Social Security even know about that? And it's because, maybe someone called in for an early fill on one of their medications, or had a conversation with a therapist, or when they got back said that they recently got back from a trip. A lot of these things show up in the records when you might not realize they're going to be in there. And daily activities end up having a very significant effect on the outcome of the case. So it's not just that you have the records and the diagnosis to support severe symptoms, but also that you have limitations in your daily life that would prevent you from doing things that Social Security would view as inconsistent with the finding of disability. I don't really love any of that. If you've ever been on an airplane, you know that a lot of people on the airplanes, elderly people in particular, are using walkers or wheelchairs, and they're not super functional. And it doesn't mean that a person who can do those things is not disabled. The same would go for attending school if you have a lot of accommodations, or caring for a young child, where you can nap, or when the child naps, or you can manage your life and take care of other issues as you are a parent. But Social Security is going to consider a lot of those other factors. And many times I don't agree with the way they look at it, but it is important to know that those things are going to be considered. And so, relevant for a case of an 18-year-old who has been disabled and is now reaching the age of 18, it's probably worth considering whether you should take that European trip that you have scheduled for next year, or whether you should do some of these things that might be viewed negatively in the evaluation of the case, even though the truth is that they really don't have any bearing on whether you're disabled or not. They are going to take that into account, so it's worth thinking about those things.
Are they looking at our social media?
They're not supposed to.
You don't have to answer it if you don't want to, but
no, the Social Security is not supposed to view social media. And that is, I believe that they have issued rulings that have said that they're not going to do that. I don't know for sure that it means that they don't. I usually check social media, especially on a new case, because I want to know what they're putting out there. And, every once in a while I might have a conversation with them about what I saw and how that could end up, getting into the wrong hands, and it could be misconstrued. I don't want people to try to hide things from Social Security. That's not what you're trying to do. That's not ethical. But I do think that if you're applying for disability, that probably some care should be taken in what you are posting on social media, particularly social media that is available to the public or anyone beyond your friend circle or contacts or things like that.
Well, I've already learned so much, but I want to know, when should I call you? When should my clients call you?
Okay.
Talk to me about that.
It probably as early as possible. Filing an application for Social Security disability is something that can be done by almost anyone. You don't have to have an attorney to do it. And the truth is that you can get through a lot of the process without an attorney if that's what you choose to do. But having an attorney involved from the very beginning can help the navigation of this massive bureaucracy that is Social Security much easier. And there are a lot of just little things that happen during the course of the application, including the application itself, which there are a few weird little questions on there that some people get stuck on, and an attorney can help with getting that filed and making sure that it's processed. You have no idea how many times I have heard from people that they filed an application a year ago, but they have no idea what happened to it and they never heard back from Social Security. And a lot of times Social Security says they never got it. And I don't know what happened to those things, but this has happened enough times that I know it's actually occurring. But an attorney can make sure that that application actually happened and that Social Security processes it. So it's important from the very beginning. And then as you move forward in time, Social Security can help with making sure that you meet all of the deadlines. As you go through your application process, Social Security will start sending you various forms they want you to complete. They have daily activity forms that they want you to complete. They have third-party daily activity forms that they want a friend or family member to complete. And they have work history forms that they want you to fill out at various stages. They usually give you 10 days to get those completed. If you have an attorney, the attorney will also be notified and can help make sure that those deadlines are met. It also means that there's two people who will be getting these notices as opposed to just one, which increases the odds of someone getting it. And Social Security is kind of notorious for saying that they sent things out and no one ever got it. And at least if there are two people with eyes on it, there's a better chance of making sure that someone caught it and that these things are returned in time. An attorney can also review the paperwork and make sure that questions have been answered correctly. And then, of course, make sure that they are submitted on time. And if they're a little bit late, they can communicate with the people at Social Security or at DDS, the Disability Determination Services, who ultimately makes the decisions. And there can be communication between the attorney and those other parties to make sure they know that something might be coming in a little bit late. An attorney can help inform Social Security about any major developments in the case, such as a work attempt or a surgical procedure or a new doctor that they need to get the records on, or anything along those lines, new imaging, hospitalizations, any of those things that can be very important to the outcome of the case. An attorney can make sure that Social Security is aware of those things. Attorneys can also help generate opinion evidence or help you understand what kind of information Social Security wants from a doctor. A lot of times the records aren't quite enough, and Social Security wants to know what your doctor thinks about your limitations. Social Security doesn't care if your doctor thinks that you are disabled or not, and that's because they don't think doctors know what it means to be disabled. But they do care about what limitations your doctor says you have and whether those limitations would add up to preventing you from being able to sustain full-time competitive work. And so attorneys can help you with that. The most important time when you need to have an attorney is at the hearing, and that would only happen if you've been denied twice. That means you filed an application, you got denied, so you requested reconsideration, you got denied there, and so then that third step is to request a hearing with an administrative law judge. And I would encourage anyone who's filing for disability, if they have been denied twice and now they need to have a hearing with the judge, that it is critical to get an attorney. A lot of times, if you don't, you get to a hearing and a judge will tell you, I'm postponing this, you need to go get an attorney. And a big part of it is that Social Security puts the burden on you to get the medical records once you get to the hearing level. And because it can take some significant amounts of time to actually have that hearing occur, there will be new records that are not a part of the file. And an attorney can help with obtaining all of those and making sure that the record is complete and accurate. An attorney can also make arguments on your behalf at the hearing and cross-examine any witnesses that might be called by Social Security, including vocational experts or medical experts, You want someone on your side at the hearing. You want someone arguing on your behalf. Attorneys also often know about each of the individual judges and what their eccentricities are and what things they like and what they don't like, and can help craft a strategy for the hearing that would give you the best chance of winning. I do believe that also, statistically speaking, that those with an attorney have a better chance of winning than those who don't. And I don't have a citation for that, but I've heard it many times over the years. And I think it makes a lot of sense to me that Social Security is going to be a little bit more dismissive of a case where there is no representation, because it's easier for them to be dismissive of those cases. They're not going to have an attorney on the other side holding their feet to the fire and making sure that everything is being done properly, and that they're not just losing an application, or not acknowledging that certain things were turned in, or any number of other items along the way, including making sure that you make all of your deadlines, including when there are denials and you need to file appeals. So an attorney can help with all of that as well. If I became disabled and unable to work, I would get an attorney involved on day one, and I would make sure that they are there from the very beginning. And that's coming from a person who knows all about Social Security and should be able to navigate the process by myself. But I would not do that, and I would encourage anyone who's applying for disability to get an attorney, and the attorneys at Tye Smith would be more than happy to evaluate your case. We do free case evaluations. You don't have to pay any money. It is also important to know that Social Security regulates our legal fee, which means that they're making sure that disabled people aren't taken advantage of. And every attorney who practices in this field, no matter who it is, has to charge the same amount. And what that is that there's no legal fee unless you win. And what the attorney gets if you win is 25% of the past due benefits. We usually call that back pay. So whatever money is owed to you at the time of the favorable decision, the attorney would get 25% of those past due benefits, and the amount the attorney can get is limited to $7,200. That's the current limit as of 2023. It was changed in 2022. It had been at $6,000 for almost a decade, and it was recently changed. So I imagine it will stay at this number for quite some time, but that number can change with acts of Congress. But it's really important to know that you're not going to have to spend any money to get an attorney, and that Social Security is making sure that attorneys don't take advantage of their disabled clients by strictly regulating the fee agreement and the way that fees are paid out. Anytime an attorney gets money from winning a Social Security claim, Social Security has to approve the amount of legal fee. And so that's why the regulated fee agreement is done the way that it is, because that allows Social Security to approve immediate payment to the attorney without even having to pay it to the claimant. So you're not going to have to spend any money to get an attorney, and you're going to have someone on your side all the way through the process. And the amount of money that the attorney could end up getting is not unreasonable or unfair. And so I do think that it makes a lot of sense to at least give an attorney a call. And like I said, at Tye Smith, we'd be more than happy to talk to you and find out what we can do to help you.
Thank you so much. All of this has been super helpful. Is it clear that not clear. Is it true that sometimes I might call and have a case evaluation? You might say, here's a few things, I pursue this, that kind of thing, but come back to us if you get denied. I mean, is that common? I hear that from clients sometimes, that they hear that.
So it is common. And I would say that I don't think it's all that common with us, but those things do happen. And those usually happen when a claimant is working. Attorneys are very nervous about taking cases where a person is working because of how much negative experience we've had with trying to get Social Security to approve a case for a person who is working. It's probably the other time when it would happen most commonly would be when a person doesn't have a lot of medical treatment. They have a diagnosis They, struggled in school. The doctor said there's not really anything that they can do. And so then there's no current evidence that shows what their symptoms are or what their treatment is, or to really help Social Security understand what's going on. And there are definitely cases where that makes sense. But most of the time, an attorney is going to feel like we need to have current records that show that you're still making efforts, that you're still trying to do things that doctors are recommending. And then those records help by creating a paper trail to show what the doctor's observations are, what the doctor is recommending for treatment, and whether or not the claimant is going along with those things. So those are probably the two most likely scenarios where that would happen, where a person is working or where they're really not in a lot of active treatment. And attorneys are usually concerned about that. So an attorney might say, hey, you need to get in and start seeing specialists for your condition. Once you do that, you can call us back and then we can take another look at this case. And in a lot of respects, that gives the attorney something to look at. They can get the new records and look at them and evaluate from those records whether a valid claim can be made. So those kinds of things do happen. It's on a case-by-case basis. There are, of course, other reasons that it could happen, but the two most common are the ones that I mentioned. And usually attorneys are willing to work with those people, but they might not be willing to right then and there. They need to see that this progress is being made, that attempts at treatment are being made, and that they would have a paper trail or something to be able to use to show that the person continues to have the conditions that they had at an earlier point in time.
Makes a ton of sense. I've taken so much of your time. Is there anything else that you feel like we haven't covered that clients really need to know other than to pick up the phone and call you guys?
Yeah. I want to go over just a few things that I would kind of refer to as common mistakes or pitfalls that people encounter during the application process. And we've already covered some of them. Reliance on older records is a major thing that happens, and thinking that they don't need to be doing active ongoing things to treat their conditions. Another one is, and kind of goes in with that, but when doctors recommend certain interventional strategies on a mental health case, it could be various kinds of therapy. It could be more frequent visits. It could be groups. On a physical health case where there's pain involved, it could involve physical therapy or injections or other things that, a claimant might say, I've done all those things in the past and they didn't work, so there's no reason for me to do them. Unfortunately, if Social Security sees a doctor recommending certain type of treatments and then those treatments are not pursued, they'll assume that it's because you're being non-compliant, and they will absolutely use that against you. So making sure that you continue to do things to support the case, to show that you're going out of your way to get treatments, to do things that maybe you don't even want to do, that maybe you tried in the past and didn't work, to continue to make those efforts to build the paper trail and to show that you are willing to do whatever it takes to get better. That can be really important. I would also say that it is critical that you are seeing specialists for your disabling conditions. And any condition that you have that's preventing you from working, it's critical that you are seeing a specialist on a regular basis for that condition. And this goes back to Social Security wanting to know that you're getting the kind of care that would be expected of a truly disabled person. And having a primary care provider care for a condition is not that. It is the opposite of that. To Social Security, that's saying, I'm stable and I don't even need a specialist for this condition. And so even though that might not be true at all, and there could be an entire story behind it, Social Security needs to see that you are going to specialists regularly for all of your disabling conditions. And then I think finally, the final concept I wanted to cover here is that you can't rely on the diagnosis. A diagnosis is not in and of itself going to win a Social Security disability claim, except in the most rare of circumstances when the condition is terminal. In almost any other situation, a diagnosis in and of itself is not sufficient. The diagnosis is the starting point to determine what your condition is, or what you have, but then they need to see the ongoing treatment that we've been discussing with specialists, the attempts that you're making. And then ultimately, one of the biggest issues that we see is a failure at some point along the way in symptom reporting. And what I mean by that is the complaints that you lodge with your doctor every time you see them. And if you are seeing a doctor regularly, but you are usually telling them that you're doing good, your medications are working, you're feeling stable, you're doing okay, those kinds of words are going to be used against you, because Social Security will say, look, you got this diagnosis and you had these treatments and they worked. You're telling the doctors that they're working. And so it's very important to understand that your words can be used against you, and that it is critical that you are reporting your subjective symptoms. What are you still experiencing? What are you still going through? And how are those things affecting your life? And those things need to be showing up in the records as much as possible. And it is a failure to just say I'm about the same, or to say that I'm doing good when you might not be doing that good overall big picture. And that even if you have had some improvement, that's okay. You need to tell your doctor about it, but you need to explain what symptoms you are still having that would ultimately support that you are still disabled. And if you can do those things, if you can see the specialist and pursue the interventions that they recommend to you, and do it regularly and diligently, and all the while continue to report your symptoms, that's going to put you in the best position to win a claim for Social Security disability benefits.
And calling you guys.
And feel free to give us a call. We'd be happy to talk to you and take a look at your case.
No, I so appreciate this. I mentioned to you before we got started, you practicing in my world for the last 16 years. I know a lot of these acronyms, but there's no benefit for me trying to guess around it. So many people have so many questions, and your support is so needed. So I thank you for sharing this time. And I know, like you said, in my world, the minute I need legal advice, I'm going to get it.
Exactly.
So I know it's never fun to pick up the phone and call or need or want to talk to an attorney, but super, super important. And I think you made a great case for that today. So I appreciate that. We're going to share your information on this webinar to make sure it's available. But thank you so much for your time today. And I appreciate everything you told us.
You're welcome. I'm very happy to do it, Emily. And good luck to everyone watching this video.